Citizens of the gallery, before a court can decide a case, it must first answer a more basic question. What actually happened? But judges do not investigate disputes themselves. The law forces the parties to reveal the evidence they possess. Documents, communications, sworn testimony. This process is called discovery, and it is where the hidden facts of a lawsuit are dragged into the open, long before a jury ever hears the case.
Most people think lawsuits are decided in the courtroom. They imagine dramatic testimony, surprise evidence, and cross-examinations that change everything. But in reality, most of the important work in a lawsuit happens long before a trial ever begins. It happens in a phase called discovery. Discovery is the process where each side is legally required to exchange information, documents, and testimony relevant to the case. It is the stage where the facts are investigated, records are produced, witnesses are questioned, and the true shape of the dispute begins to emerge. In many cases, discovery determines the outcome long before a jury ever hears the case. Understanding discovery is essential to understanding how modern litigation actually works. Discovery is the formal process by which the parties to a lawsuit obtain evidence from each other. This process takes place after a lawsuit has survived early motions, but before trial. Its purpose is simple. Both sides must have access to the relevant facts before the case is decided. Courts do not allow trial by surprise. Instead, modern litigation operates under a principle called open discovery. Each side is entitled to request information that may be relevant to the claims or defenses in the case. That includes documents, emails, financial records, contracts, medical records, business records, internal communications, and witness testimony. If information is relevant and not privileged, it generally must be produced. Discovery exists for several important reasons. First, it prevents surprise at trial. Historically, litigation sometimes allowed parties to reveal evidence only when the trial began. That approach often rewarded concealment and strategy rather than truth. Modern discovery rules attempt to prevent that. Second, discovery helps both sides evaluate the strength of the case. Once the evidence is revealed, parties often gain a clearer understanding of the risks involved. This is one reason many cases settle after discovery. The facts become clearer. The uncertainty decreases, and both sides can make more informed decisions. Third, discovery allows courts to ensure fairness. If one side controls important information, such as internal company records, discovery rules force that information into the open. Discovery is not a single procedure. It is a collection of tools used to gather information. The most common include interrogatories. These are written questions sent from one party to the other. The receiving party must answer them in writing and under oath. These questions often address basic facts, timelines, and identification of witnesses or documents. Because the answers are sworn, they carry legal weight and can later be used in court. Requests for production. This requires a party to provide documents or electronically stored information. In modern litigation, this often includes emails, text messages, internal reports, databases, and business records. Electronic discovery has become one of the most time-consuming and expensive parts of modern litigation. Large organizations may have millions of electronic documents that must be searched and reviewed. Requests for admission. These are statements that one party asks the other to admit or deny. For example, admit that the contract was signed on June 1st. If admitted, that fact is established and no longer needs to be proven at trial. These requests are often used to narrow the issues that remain disputed. Depositions. These are sworn testimony taken before trial. A witness answers questions under oath, while a court reporter records the testimony. Depositions allow attorneys to evaluate witness credibility, preserve testimony, and explore factual details. Depositions can be used later at trial to challenge inconsistent statements or to present testimony if a witness becomes unavailable. Discovery is broad, but it is not unlimited. Courts impose several important boundaries. Relevance. The requested information must be relevant to the claims or defenses in the case. Parties cannot demand unrelated personal information simply because litigation is pending. Proportionality. Modern discovery rules require that requests be proportional to the needs of the case. If a request would require enormous effort for minimal relevance, the court may limit or deny it. Privilege. Certain communications are protected from disclosure. The most well-known is attorney-client privilege. This protects confidential communications between a client and their attorney made for the purpose of obtaining legal advice. Other privileges may protect medical, marital, or certain governmental communications. If information is privileged, it generally cannot be compelled in discovery. Discovery is often one of the most contentious stages of litigation. Parties frequently disagree about what documents must be produced, whether requests are too broad, whether certain information is privileged, or whether responses are complete. When these disagreements arise, the parties may file motions to compel, asking the court to order compliance. Judges often spend significant time resolving discovery disputes. In complex litigation, discovery disputes can last months or even years. Discovery is a powerful tool. Because it requires disclosure of internal information, it can place enormous pressure on parties. But that power can also be abused. Examples of potential abuse include overly broad document requests, excessive deposition schedules, requests designed to increase litigation costs, or a strategic delay in producing documents. Courts attempt to manage these problems through supervision and sanctions when necessary. When a party fails to comply with discovery obligations, courts have authority to impose sanctions. These may include orders compelling production, financial penalties, exclusion of evidence, adverse inference instructions to the jury, and in extreme cases, dismissal of claims or defenses. Courts take discovery obligations seriously because the integrity of the litigation process depends on honest disclosure. Many lawsuits never reach trial. Discovery is a major reason why. Once the evidence is revealed, several things may happen. A party realizes the case is weaker than expected. Damaging documents emerge. Witness testimony contradicts earlier statements. Legal theories become unsustainable. At that point, parties may settle the case, narrow the issues, file summary judgment motions. In many cases, discovery effectively decides the outcome long before a jury is ever involved. Discovery is not primarily about persuasion. It is about information gathering. Attorneys use discovery to learn what the other side knows, what documents exist, what witnesses will say, what evidence supports or undermines the claims. The goal is to eliminate uncertainty. Once the factual landscape becomes clear, the legal arguments become more focused. Discovery is one of the most important phases of modern litigation. It ensures that evidence is shared, facts are investigated, and surprises are minimized so that both sides can prepare their cases. Without discovery, trials would become contests of hidden information. With discovery, the system attempts to create transparency before the final decision is made. When people imagine lawsuits, they usually imagine the trial. But in reality, the trial is often the final chapter of a much longer process. Discovery is where the investigation happens. It is where documents are uncovered, witnesses are questioned, and the true factual picture begins to emerge. By the time a case reaches trial, the parties usually know far more about the evidence than the public ever sees, and that is by design. Because in modern courts, justice is not supposed to depend on surprise. It depends on information, and that is the result of discovery.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.